whenever I can encourage those people that are bringing forward information that's going to help us have a better life. And the fact that each one of you are here, there's no question in my mind that you got to come away with knowledge about a very complex subject and answers that most people in the community and the country are not that familiar with. And you have such an outstanding board that it's going to be good. It's a particular interest to me because I was born and raised on the Harlem streets in the 1930s. And at that time, there was no such thing as civil rights. The cops just beat you. But the good part of that was they didn't give you an arrest record. So I can't tell you the number of times I've been in 32nd precinct, but I ain't got no record, you know, so that's the good part. But as a public official, people who are trying to make it during hard times, I can't begin to tell you the mothers and the young people that said, listen, I made a mistake. Can you get it expunged from my record? Expunged me just like it didn't happen. Other people say, hey, all I want you to do is just have the record sealed so that nobody can see it. And then, of course, there's those people, just tell the governor to pardon me and forgive me for what I've done and let me get on with my life. Those are three separate things, and before you leave here, it wouldn't surprise me if you lit up a little office with a law sign on there saying, come here if you want pardons, leniency and whatnot, but good luck to you. And again, hey, Judge.
Hi, how are you? Good to see you.
Good to see both of you.
Yes.
Thank you for sharing the time with us.
Always.
I want to now introduce the Queens County Criminal Court Judge, Althea Drysdale, who will be our moderator this evening. She was a defense attorney for 27 years before being appointed as an interim civil court judge in February of 2015 and has been serving in criminal court since. Most recently, she served as a senior trial attorney for the New York County Defender Services and appointed to the bench in January of 2016. Please give her a warm Harlem welcome, Judge Althea Drysdale. Before she comes up, I want our senator to have a few words, please.
Good evening, everyone. Good evening. First of all, I'd like to give a huge round of applause to our Assemblywoman Inez E. Dickens for bringing up such an important topic at a very important time. Thank you so much for coming out. I guess we'll be very brief. One of the things that has been top of my agenda has been criminal justice reform in the New York State Senate. And I just want to say to you, we have some of the most draconian laws in New York State as it relates to criminal justice across the board. I mean, even when you talk about this issue of sealing records, I mean, the fact that 2 misdemeanors, you have to wait 10 years in order to get that sealed, to me, is a little too aggressive. And it's something that we should revisit, and that's something that I will look to revisit as well. Let me say, in the New York State Senate, just today, a Republican colleague of ours made the comment that the opioid crisis is not a ghetto drug. Doctors' kids are being impacted by opioids. And so it is alarming to him because it's growing in his district. But that is first of all, and I'll be brief, that is the mindset that the Assemblywoman and I are dealing with. We have people who believe that what happens in our communities is not as important as what happens in other communities. And so it is important that we know the facts, and that's why I'm so glad that our Assemblywoman is doing this, but it's important that we have your support to know that, listen, we are gonna have to fight together to make sure that we have fair criminal justice laws for all of us and not just for a few. And so, Assemblywoman, thank you so much for this. Sign me up. And do I need to do this? Oh, I'd like to acknowledge Jackie Rowe Adams, who has just arrived from Harlem State. And I see we also have our district leader, Wilma Brown Phillips, from the Frederick Samuel Democratic Club. So thank you. But listen, like I was just saying, I'm so glad, this is a great attendance. I'm glad everyone's out here, but understand that the Assemblywoman and I are facing some strong headwinds, people who do not want any of this to happen. So we need to know the facts, and we need to fight in Albany to make sure that we pass more laws that provide opportunities for our people. Thank you very much.
And the state committee person for the 70th returned, Lonnie Davis. And I announced Kim Parker as a candidate. Is she still here? Thank you. Now we're going to have our moderator, the esteemed Judge Althea Drysdale.
Good evening, Harlem, and welcome.
Good evening.
I'd like to thank our co-sponsors, especially Inez Dickens, for being here tonight. Let me introduce our panelists to you. First, we have the Honorable Milton A. Tinglin. He's a son of Harlem. Milton Tinglin is a retired New York State Supreme Court Justice. He is now the first Black county clerk and commissioner of juries in the history of New York State. He now also educates and assists the formerly incarcerated on certificates of relief, good conduct, voter rights, and registration. I'm happy to have him here tonight because we will be talking about certificates of relief, and I need him to tell you exactly what that is, as opposed to the sealing statute, which is 16059. I'd also like to introduce to you Ayanna Surratt. Ayanna Surratt is an assistant district attorney with the New York City County office, where she has served since 2004, and she was my adversary when I was a lawyer. In her 13-plus years as a prosecutor, Surratt has worked on a wide variety of criminal cases, handling every aspect of prosecution, from pre-arrest investigation through sentencing and post-conviction. In addition to investigating and litigating cases, Ms. Surratt has served in a variety of administrative roles in the DA's office, including supervising junior assistants in case intake, leading teams of attorneys in focused prosecution, leading the office's college intern program, and as a member of the permanent hiring committee. She's also a significant member of this community. We also have Seth Steed with us. Mr. Steed. Mr. Steed is an assistant district attorney in the Conviction Integrity Unit of the Bronx County District Attorney's Office, where he investigates claims of actual innocence and wrongful conviction. Seth has served as an appellate counsel in the Criminal Appeals Bureau of the Legal Aid Society and as a staff attorney with Neighborhood Defender Services of Harlem. We also have with us today Kate Wagner Goldstein. Ms. Goldstein has been an attorney at the Legal Action Center since 2010. She advocates for people who have experienced discrimination because of a criminal record, very apropos tonight, drug or alcohol history, or HIV status. She advises and trains organizations about anti-discrimination and privacy laws relating to criminal records, substance abuse, or HIV. Prior to joining the Legal Action Center, Ms. Goldstein was an attorney at Bronx Defenders, where she represented people with criminal and family court cases. Last but certainly not least, we have Xavier Donaldson. Mr. Donaldson is a senior trial counsel and founding partner of Donaldson and Chillis LLP, with offices in New York City, and is a former assistant district attorney of Bronx County. He is admitted to practice law in the courts of the state of New York, the Southern and Eastern Districts of New York, and state courts of District of Columbia, Western District of Pennsylvania, Chicago, Miami, and New Jersey on a pro hoc vice basis. Mr. Donaldson is also a professor. He teaches the law. He practices the law. I am so happy to have him here tonight. Let me say that 16059 is pivotal. Pivotal. It was passed on October 7th of 2017. The passing of this piece of legislation signals how strongly New Yorkers feel about second chances and the understanding that everyone deserves a chance at rehabilitation. And tonight, we will be able to see how this legislation will impact our community. So let us begin. Mr. Donaldson, start us off. What exactly is 16059, and why is it so pivotal at this moment in our community?
Okay, well, let me say this first.
First, before you start, let me just tell you all, 16059 is not, I repeat, not an expungement statute. It is a sealing statute. Everybody must leave here understanding that, because that's a crucial distinction. A sealing statute just gives you the benefit of sealing the record. Expungement would take it completely away. When the record is sealed, certain agencies will still be able to look at it if you apply to be a police officer or if you wanted a gun permit. The crimes that we will be talking about tonight are all of a non-violent variety. Do understand that. This is not an expungement statute. All right? Mr. Donaldson, start us off, please.
What the judge said. So all that's correct, but I guess I wanted to, I need a mic?
Take it.
Oh, man. I don't need a mic. Besides you.
Yes, you do.
I need a mic?
Yes.
Wow, okay.
It's important stuff.
Important stuff, very important stuff. So I guess the first thing I want to say is, and this is important, everything Judge Drysdale said was absolutely correct, but what I want everyone to understand is that, how can I be really truthful?
Yes.
Okay, so what I want everyone to understand is that all New Yorkers don't want this. Let's just be clear on that. And I'm saying that from experience because I'm also part of the New York State Bar Association's executive committee. And I've been a part of that for about, criminal executive committee, for about 10 years now. And I started this journey with them when I did it back in 2011 or 2010 or something like that. And believe me when I tell you, there are lots of people in this state that do not want sealing and they do not want expungement. They really want whoever has a prior criminal record to keep that record for the rest of their life. New York is one of the few states that didn't have any type of expungement or any type of sealing, so we were really on a mission for the last 6 or 7 years to get this. So this is a step in the right direction. Everyone's true. We want to get expungement at some point, This is not expungement. This is sealing, but it is a step in the right direction. Now, why is it important? It's important because anytime you have a conviction of any kind, misdemeanor up to a felony, there are what we call collateral consequences attendant to that conviction. And what do I mean by that? That simply means that anytime you get that A misdemeanor or that B misdemeanor or that felony or whatever kind of conviction, not only are you getting punished by the criminal justice system for that conduct, but there are what I call ripples or collateral consequences related to that conduct. Jobs, where you can live, federal benefits, state benefits, licenses, all types of collateral consequences that come along with that. And so sealing and expungement is a way to make sure that persons who have committed certain criminal behavior can re-enter society in a way that doesn't affect them going forward. So that's why this is important, because as I said 7 years ago up in Albany to a lot of folk who wasn't listening to me, that it's important for society to have persons re-enter and be able to work and participate in society fully without these handcuffs from what they did 10, 15, 20 years ago. And it's not only important to them, but it's important to society, because I always tell people, I like people paying taxes. It helps me out. So if you can work and continue to pay taxes, it helps society. But if you can't, because you're handcuffed because of a prior criminal conviction, then that does not help society. So if the question was, why do we need how does it help? Or
What is
what is it?
16059?
It's
What does it cover?
It covers non-violent criminal convictions, no A felony convictions, no violent criminal convictions, no sex offender convictions, from what I understand. So if you have any other conviction outside of those and you don't have more than 2, then you're covered. Oh, and there's a 10-year period between the sentence and the application period. So that's what it covers in general. Now, again, those are a lot of exceptions. Those are a lot of, like, heck, man, that takes us, I'm gone, I can't do it, whatever. But on the other hand, that's going to help out millions of people. I can guarantee you that. So it is a step in the right direction. It's not where we want to be. We're still working on it. We're still trying to get this expungement thing, but it is a step in the right direction. So it does help out those persons who have 2 or less, I think, convictions, no violent convictions, no sex offender convictions, no A felony convictions. So that means A felony means really serious stuff. Big drug cases, murders, things that I normally get called for. So things like that, no. Other crimes, yes.
Can I give a couple
Yes.
loopholes?
Yes.
That,
Ms. Goldstein, go ahead, please.
yeah, so that was a great overview. And one of the things that we're trying to make sure gets out there, though, too, is that there are a few loopholes. Not many. There are still lots of limits, but a couple loopholes. One is it's only violent felonies that are not eligible. So misdemeanors generally are eligible except for sex offenses. Another thing to flag is just that violent felonies in New York State is a super confusing term. It is not intuitive, so don't make an assumption about what's a violent felony or not. It's really complicated. And we are doing advocacy also around what counts as a violent felony, because there are some things that somebody would clearly think is not violent that is currently classified. And then one other thing I wanted to flag is that if somebody has a violent felony first, but then has a later eligible misdemeanor, then that later misdemeanor should be sealable. So there are things to look for in this, but it is true that one of the things that we also find is we're just talking to people and, checking off the like, oops, now I'm not eligible. But there is some room there to just be aware of. One other limitation, though, is that only one of the convictions, or only one of the cases can be a felony case. But something to bear in mind is that if you have multiple convictions that are part of the same criminal transaction, then they count as one conviction for this purpose. So sort of think of it as cases to some degree, and again, what counts as a criminal transaction is something you're going to need to consult with a lawyer about, but if it's part of the same criminal transaction, that's one conviction.
All right, thank you very much. And I'd like to bring Judge Tinglin in right now. I'd like you just to contrast this sealing statute with the certificate of relief, which is more immediate. So for the 16059 statute, you need to wait that 10-year period. Judge Tinglin is going to talk to you about certificates of relief that you can use on non-violent crimes as well, and that also cure any kind of collateral consequence that you might have about getting a job or where you live. Judge Tinglin, go ahead, please.
All right, good evening, everybody. Good evening. Good to see a lot of familiar faces. I'm not sure if I should be speaking right now because, I mean, those of you that know me, this is what I do. So, how many of you came here tonight thinking that either for yourselves or for a family member or for a loved one, that you were going to find out how to erase their criminal record? Okay. So that's one of the things that makes this evening so important. You know, I walk the streets, go anywhere. I go to Rikers, I go to Otisville, I go to Attica, and it is a mantra. Those of you that have been in, people will come to you and they will be, yo, brother, I've been out for 10 years. I've been good. I've been straight. I want to get my record expunged. Expungement means erased. You heard Mr. Donaldson. No longer exists. You heard Judge Drysdale. It no longer exists. And so one of the things about tonight that you've got to walk out of here with no misunderstanding, is that the state of New York never expunges records. Never expunges records. Everybody got that?
Got it.
So those of you that tell you I've been inside, I know, brothers and sisters, everyone's told me, it is not true. The state of New York never expunges records. You can get a pardon from the governor of the state of New York, and your record will not be expunged. So that leads me into, that was not to tell you to discourage anyone. What it is a wake-up call, because what we have to do is what we can do, and not spread rumors about what we can't, and not continue to miseducate each other about what we cannot do. But there are things we can do. We can apply, and we can go forward to get our certificates of relief and certificates of good conduct, and when qualified and eligible, to seek to seal the records of ourselves and our loved ones. So, you've heard about 16059, it's brand new. You've heard Judge Drysdale, you've heard this panel state that it is a sealing statute. It means that your record would be sealed, okay? Now, they didn't even have this law when I was a kid. You know, when I got stopped in the street and I had a little something in my pocket.
Hypothetically, allegedly.
What was it?
As
Allegedly.
my lawyer said, hypothetically.
Allegedly.
Allegedly.
Yes, allegedly.
But as you also heard the congressman say, that was back in the day. Basically, you got it, threw it away, they kept it, whatever, that was all there was to it. Now today, you get a record, you get picked up, you go in. But your first offense for a minimal amount of herb, you can get an ACD, an adjournment in contemplation of dismissal. Get your records dismissed, and it is sealed. So you get sealing. You also have things today, 16058, where you may get picked up on drug charges and you get placed to a drug diversion program. And if you successfully complete it, the judge has the ability to seal your record. Sealing does not mean that no one can ever see it. It is still available to law enforcement, okay? But at the same time, that's a hell of a lot better than somebody being able to go online and pay $40 and look up your entire criminal history.
That's right. That's right.
Okay? Yeah, that's right. State of New York sells your record.
That's right.
Oh, you know, we need the money. I'm just kidding. But for over 2 years now, and I'm glad I have my colleague here with me, but been going around and talking and trying to facilitate and educate about certificates of relief, which is the corrections law. Certificates of relief give you rights back that you have lost based solely on your conviction. Certificates of good conduct give you the same thing. The only difference is what your crime was, the severity of the crime, and the waiting period. Okay? Now what these do is they remove barriers to employment, to housing. It gives you rights. Example, you have a drug conviction, okay, but you're applying for a job as an IT consultant. One has nothing to do with the other. If that drug conviction was held against you in seeking out or gaining that employment, it is illegal. It's a violation of the executive law. You can sue them. You can get a job. Certificates of relief, and this is one of my pet things. How many of us have relatives that got 5, 6, 7, 8, 9 misdemeanor convictions? Okay? Jumping the turnstile. Okay? Possession. Trespassing. Simple things. But we don't get the certificates of relief. And part of the problem is the defense bar. Because you can apply for a certificate of relief at sentencing.
Yes, definitely.
Okay, what's our reality? You get picked up, you spend 5 days in jail, you can't make bail, come out, what do you get? Plea to the charge, time served. Who's going back to Rikers? Nobody, so you take it, and you go whoop-de-doo, and you get up and you walk out, and nobody asked for that certificate of relief. Now 3 years later, you're going to get a job at McDonald's. And there it is. All because nobody asked for it. Now, you can get it at sentencing, you can apply for it later. I want to let the rest of the panel get in. But there's things to do, all right? It's very easy to go and make your application for the certificate of relief on a misdemeanor. And our young kids have too many of them. They have too many of them. You make a mistake when you're 16, 17, 18, and then it comes up when you're 21, 22. And we have to start doing it. We've got to flood the system with applications for the certificate of relief for our kids, for these misdemeanors. The felonies, more complicated. I'll be happy to get into it with anybody a little bit later. But one of the things that was said tonight is that I'm not only the first black county clerk in the history of New York State, I'm the first black commissioner of jurors. And that is huge. And I'm going to tell you why. You know, I talked about how many of us, our family, our brothers, our sisters, our cousins, made a mistake at 18, 19, 21, did a dime.
I mean, 10 years for y'all.
I'm sorry, a nickel, did 20, whatever. So you did the dime when you were 19, you came out, you're 29. You know what? You said, I'm not going back. Straightened up, you got a job, met a beautiful woman, met a beautiful man, had a family. You went to church. Now you got a Boy Scout troop. You coach Little League. You've done well. But you want to serve on a jury? No. Judiciary law of the state of New York says you got to be 18 years old, a resident of the county, a citizen of the United States. You have to have the ability to communicate and understand the English language, and you cannot have been convicted of a felony. Okay? Now, think about how many of our community are now deprived from sitting on a jury.
A lot of us.
Yeah, we want to complain about racist juries. And we want to do all of that. Well, guess what? The corrections law says that with a certificate of relief or a certificate of good conduct, no right, privilege, or duty, which was forfeited solely as a result of your conviction of a felony, may be withheld from you. And guess what that includes? Serving on a jury.
That's restoration.
Yeah, but it's not that easy. What it means is that you can qualify to serve on a jury. But then they tweaked it a little bit more, and they said, in the discretion of the commissioner of jurors, you may be qualified to serve on a jury.
Ding, ding, ding.
Well, I looked in the mirror this morning, and I saw the commissioner of jurors. So I want all of you, I'll be around, I want all of you to keep and look and get it, because we're gonna get it out. I already have 5 candidates that I'm just using as my initial ones that fit that profile I talked about. And I'm about to qualify them to sit on a jury.
Yeah.
And you
All
watch.
right.
So we'll have more to talk about. Thank you all for being here.
Thank you, Judge Stingley. Ayana, let's get back to 16059.
So it's sort of echoing what everyone has already said. It's not an expungement statute. It's only sealing. And a great way to understanding it is that it's civil sealing. So when you apply, there are certain requirements, and I think some have already mentioned what those requirements are. You have to have.
Let me ask a question. As a prosecutor, it's going to come to your office. Tell me the things that you're looking at in making a decision whether one gets a sealing, whether one is denied, or whether one has to go to the hearing. Give me the statutory period as per 16059 that one has to wait before they get an answer to the application. Walk me through the process. Pretend we know nothing about it. Tell me I've gone to the website, I filled out my application, it's now on your desk. Ms. Surratt, tell me what it is that we're doing here.
Okay, so as a matter of course, the Manhattan DA's office, Mr. Vance's position, the default position is to not oppose sealing if all of the statutory requirements are met.
Give me
At
the requirements.
baseline,
I'm sorry.
yeah, so that's for both misdemeanors and felonies. So in our office, at baseline though, my understanding of the statute is you can't have more than 2 convictions in order to qualify. So you can't have like 5 different cases, even if it's 5 misdemeanors. If you have 5 misdemeanors, you won't qualify. So it's either 2 misdemeanors or a misdemeanor and a felony. If you have 2 felonies, you don't qualify. So right off the bat, you can only be convicted of 2 criminal offenses as defined by the law.
And
right?
have the waiting period of 10 years.
And the waiting period is, so after that, after the, you have 2 convictions, it's 10 years from your most recent conviction. So let's say you have a misdemeanor and a felony. Now we know in terms of the felony, it can't be a violent felony. Mr. Donaldson has talked a little bit about that. It can't be anything that classifies as a sex offense. Can't be anything that classifies as sexual exploitation of children. There are certain misdemeanors that are sex offenses. Those would not qualify. So things like subway grinders, for instance, those are considered sex abuse. Those are misdemeanors. If you have that, it will not qualify. I see some questions, but just let me finish this part. And so at baseline, what we're looking for is it 2 eligible offenses? And if you're eligible, do you satisfy the 10-year waiting period? And then we move from there. And if you meet those particular requirements, we then don't oppose sealing. We have 45 days if we do oppose sealing. Let's say some of your paperwork that you submit, you're required to say how it is you've spent your last 10 years, sort of showing your rehabilitation, the reasons why you should receive sealing. Now, it's sealed and it's a civil sealing because it means it's removed from the records of the court. So let's say you go for a job. Employers do background checks. If you receive the sealing, if you receive that sort of relief, it means that when that employer goes and do the background check, your two eligible convictions, they're sealed and they're not able to view that. But because it's only sealed, it doesn't mean that other agencies can't see it. So certain law enforcement agencies can still see it. So the police department can, the FBI can, district attorneys can also see it. And let's say you want to go to a gun shop and purchase a firearm. When they do their background checks, those 2 prior convictions will show up. So those sorts of checks are not sealed. So it's only like a relief from civil sealing. Okay?
Thank you. Mr. Steen?
Thank
What's
you.
your office doing? Talk to me about what your office is doing and what your expectations are.
Absolutely. Good evening, everyone. I'm happy to be here. This is exciting. This is the first time that New York State has endeavored to seal criminal records, and it's very important. There was some diversion under 16058, but this is different. This is real. DA Clark believes that, I work in the Bronx with District Attorney Clark, and she believes that the role of the DA is not just to convict, it's to do justice. And so she's empowered me and another assistant in her office to look into these cases. And I want to read to you the general purpose of the penal law. It's in section 1.05 sub 6. A lot of people don't think about it. But it says the general purpose of the penal law is the rehabilitation of those convicted and the promotion of their successful and productive reentry and reintegration into society. And I think that this statute allows that or can begin that process. So everyone has already sort of explained it, but I want to tell you how I'm thinking about it. So generally, these are the questions I think you should ask yourself to figure out if you're eligible. Have you been convicted of 2 or fewer crimes?
Well, let me stop you right
Sure.
there. I think the population
We've
want to
got
know
that.
whether or not
What's
one
going on in the
needs-
Bronx?
No,
No.
whether one needs a lawyer in order to do this.
Sure.
I've already paid for a lawyer, and I've been
I invite
convicted.
all of you to go to our website. It's bronxda.nyc.gov. On that page, we have instructions for how to apply for this sealing. And I'll repeat it again. It's bronxda.nyc.gov. And if you click on that link, it will take you to OCA's, Office of Court Administration's website. And on that website, they have all the instructions, they have the form that you need, and they have a list of all the DA's offices. So OCA has a form that you can fill out. And in that, you have to first go to the courthouse, obtain a certificate of disposition for any of your cases. That you can get at the clerk's window, and it costs $10 per case. So if you have 2 cases, $20. Then you, sometimes it's free. You
If
can get a
there's
waiver.
person- Yes.
Or, I don't, you can get a waiver, Judge?
Yes, you can.
And so you fill out the form that OCA has, you attach your certificates of disposition for 1 or 2 cases, and then you have to write an affirmation, like the ADA said, saying basically what you've been doing and that you've been out of trouble for 10 years. And then the applications that I've seen, I've received 13 of them so far. People have like attached a diploma, talked about their work, got a letter from their employer, things to let the court and the DA's office know that they've been rehabilitated or that they're doing what they're supposed to do. So once you do that, you serve a copy on the DA's office and file your motion with the court with the attachments. Then, like the ADA said, the prosecution has 45 days to respond. But I can assure you, just like my colleagues in Manhattan, the Bronx DA's office is taking the position that if you are eligible, we are consenting to it. So everyone who's eligible, we are not going to be opposing it. 13 people have applied so far, and what happens when you apply, you file your motion, if your paperwork's right, the court sends a copy of your rap sheet to us, and you can get it as well. We look at it, determine if you're eligible, and then write like a 1-page affirmation saying, yes, this person is eligible, we consent to sealing. And then after that, the court just grants it. I met with the administrative judge for criminal court and the administrative judge for Supreme Court in Bronx County, and they're of the opinion, I can't speak for them, but they're saying if you're eligible, you're gonna get it.
Point of information. If for some reason your application is denied, so the people get, the DA's office does, they do get 45 days. If for some reason that they deny your application, all is not lost. There can be a hearing before a judge, and the judge will decide based on the paperwork. So the onus is upon you who's making the application to tell me how splendidly you're doing in the community. If you're working, put that in the paper. If you have a diploma, put it in the paper. If you're a stay-at-home dad, that's also important. Bring me everything that you've got and put it in your paperwork.
Do you need an attorney to come before the court for
You
that?
do not.
No.
You do not need an attorney in this procedure at all. 16059, you do not need an attorney. Now, I'm not putting attorneys out of work, but you do not need an attorney.
Also can't afford anyway.
So you heard him refer to, I'm sorry. You heard him refer to the applications. This is, you can go on the nycourts.gov website. And it's also PDF. So it's interactive, it means you can fill out the forms online. Okay? You can fill them out on the computer and print them. So you'll have that. All right, so you want to get that, and you want to get it done. As to the question about whether or not you need a lawyer, in addition to that, the answer is no. You do not need a lawyer. However, if you Google this, if you go online, you will see numerous websites for attorneys and law firms that are inviting you to come and pay them to do the application for you. Okay? So be aware.
But you also got the broad defender that go for free.
Oh, there's a lot of people that do it for free, and I'm so glad that Catherine's here from the Legal Action Center. Okay? They are warriors. Many of you don't know about them, but they are true, the Legal Action Center. They are true warriors in this battle.
Give him a hand, give him a hand, y'all.
Ms. Goldstein, I'd like,
Before she speaks, I want to announce that Stanley Gleaton from CB10 is here. I want to announce Beverly Boston, the President Emeritus, and the President of the Tenant Association is here. Gail Buey, I want to thank you, and Charles Simmons for volunteering.
thank you. We'll have a healthy question and answer period once we are finished going through the mechanics of what it is. Ms. Goldstein, did we miss anything? Would you like to add anything, please, just about the application process and how one gets it before the DA's office to make the determination?
But I was just going to add that there are a number of organizations that are providing free advice about this and help if you have questions about your eligibility or questions about the application, or if you feel the need for representation and assistance filling out the application. So Legal Action Center is offering that. You can call us, leave a message. You'll get a call back from us. We're also working with a pro bono law firm, corporate firm that's doing cases for free, and a number of other providers like Legal Aid Society, Community Service Society are also providing free assistance, as well as Bronx Defenders, who we're working with on that. So there are, if you do have questions about this or you want assistance before you submit your application, which we absolutely, first of all, we want to say absolutely this process should be something you can do without a lawyer, and should be streamlined ideally even further, but people may be well served to consult before submitting an application just to make sure that they're able to put the best application forward up front, so that as much information as is needed can come across.
Mr. Donaldson, go on, please.
I just want to make two things, two quick notes. One, you've heard from two very, 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 very polished, experienced, well-informed prosecutors. I'm going to say this very clearly, and I don't care who gets mad at me. I really don't. Do not leave this room, go tell your family members or yourself, fill out an application, say, I was told by the DA that my application will be granted. Do not do that. Do not do that. I'm telling you right now, do not do that. That's not the point of what they were trying to tell you. What they were trying to tell you was that you ought to fill out your applications, or have your family members fill it out, make sure it's thoroughly filled out properly, make sure you meet the requirements properly, and then from their point of view, if you meet the requirements, then they normally will consent. It's up to the judge to then make a decision. But do not leave here and say on your application, or go to in front of a judge, or go tell your cousin or your aunt, whoever, that, listen, I was at a meeting in Harlem, and the DA's office said they're going to give it to me no matter what. Don't do that. Because if you do, I'm going to be the defense attorney that says they didn't say that.
Right.
So I'm telling you right now, don't do that, because that's not how this works. Secondly, according to what Judge Tingling said about jurors, and I have to say this every time I'm with Judge Tingling a lot, but I got to tell you this. A lot of you all, non-felons, get juror notices and don't come.
At all.
So I'm the one that tells people, if you get a juror notice and you are eligible to be a juror without any kind of assistance, be a juror. Stop complaining, be a damn juror. Because I'm sick and tired of going to court and not seeing people in court and saying I can't do it or whatever the hell you say. Be a juror. So again, I know people gonna get mad at me, but I don't care. Be a juror. If you can be a juror, be a juror. Be a part of the solution. Stop being a part of the problem. Be a juror. That's it for right now. Sorry.
We've also been joined by District Leader William Allen and Deneen Brown Blackman from CB10.
Yeah.
Thanks for being here. Mr. Steve, go on, please.
Thank you, Xavier, for making that point clear. If you're eligible, we're going to agree. But I just wanted to make one more point about the Bronx. We've partnered with Bronx Offenders and the Legal Aid Society that you can go to them and they can help you assess if you're eligible. The representatives there will contact me or my counterpart and we'll run what is a repository rap sheet to try to figure out preliminarily if you're eligible. So we've been working with institutional providers to try to help people screen and figure out, because you may remember, oh, I have one conviction or two or three you don't quite know. In the Bronx, we can help with that. And then the other issue is some people have convictions in different counties. So if you have two convictions, one in the Bronx, one in Manhattan, you file in the county where the most recent conviction happened. Or you file in the county where the most serious conviction happened.
Did you hear that? That's very important. Say that again, Mr. Steve.
You have to be 10 years since your last conviction, right? But you file in the county where the most recent conviction happened or where the most serious conviction happened. But you have to serve both DA's offices in those if you have multiple counties. So it's a little bit confusing, but there are people like the Legal Action Center, Bronx Offenders Legal Aid that can help, and you can call our office as well.
All right, before I take questions, I just want to get into one more thing so that you have the full month before we delve into questions. Ms. Goldstein, would you discuss with us some of the factors that one is looking at in deciding whether or not one will get the ceiling?
Well, I far prefer the approach of just if you're eligible, you get it. But it is true there are some discretionary factors, and depending on the county you're in, I mean, it sounds like Manhattan and the Bronx are really focused on eligibility, which is great. That's the bar you have to meet to be able to be considered. But judges and some DAs may be looking at also some other factors that have to be considered, or that may be considered. So those are things like how much time has passed. It has to be at least 10 years, but it may be longer. And so how much time has passed. The circumstances and severity of the conviction that you're applying to seal, as well as other convictions. If perhaps you have like an eligible conviction that you're not applying to seal, they may still look at that. And then they'll also, a really important factor is what you have done since then. So basically, positive evidence of change in your life. And so then that's a really important thing potentially to put forward. So that's where people are submitting, where things like diplomas or letters of support, letters from community members who you have, who can attest to things in your life. Various types of things may be helpful. We have on our website, which is www.lac.org, and we also have over on a table there a flyer with examples of the kinds of things that can be helpful for evidence of rehabilitation, and that can apply both for the sealing application, but also, for example, if you're applying for a job and you're concerned about a conviction and how that's going to impact you. We're not going to get sidetracked into the various protections against discrimination based on convictions in employment, but that is another area, for example, where you may benefit from gathering in advance things that you can show, things that you can use to show how you've changed since the conviction.
All right, Mr. Wright, anything else, please, to add? Thank you.
There's also one other factor that they consider. In terms of sealing, and that is if it's a conviction where there was a victim and then there's a victim statement. So an eligible offense, could be like larceny. But if the person whose money was stolen writes a letter and there's a record of that letter, that's another factor that the courts will take into consideration.
All right? All right, so I think we now have a full breadth of 16059. I'm going to open the floor up to questions, please. In the blue shirt, you've been waiting patiently. Go on, please.
Good evening, everybody. I'd like to first thank Ms. Dickens for allowing us this opportunity to get this information and to put it out. For the district attorneys and for those of the law field, in this community, 2 arrests is not enough, and that line is too small for this community. You have to understand, we just came from 10, 15 years of Giuliani and Bloomberg illegal process of locking young men and women and men up for. One time I sat on the stoop next to my building and got locked up for trespassing.
Mr. Steve, do you want to speak to that?
And then had to cop out to a misdemeanor because, for what? For trespassing? So what I'm trying to say, the most important part I'm talking about is that line is too small in order to be productive for our community.
And I thank you for your comment, and I agree with you. And I think Senator Brian Benjamin said that in the beginning. 10 years is a long time to wait. If I did my time, I came out to society, it's like I haven't paid my debt. So two convictions in a 10-year period, I agree. And my hope is that we can start the process now, right? We get as many people that are eligible signed up and get their convictions sealed, and then we can go back to the legislature and people like Xavier and other stakeholders, and we have lawmakers here. We can say, look, our community is doing great with this 10 years 2 conviction thing. We need 5 years and 3 convictions, or 4 convictions, or 5. So I'm with you all the way, but we have to start with what we got.
All right, let me just add something to that. In as much as we have 16059 and it only covers 2, I think it's a beautiful starting point. We also have certificates of relief that is being underutilized. That is immediate. You don't have to have the statutory period of time, nor do you need to wait 45 days. Do you see? So that's an underutilized tool. And I invite people to read up on Corrections Law 700. Thank you.
I'm sorry, I just want to say one more thing before.
I got to give other people an opportunity. In the very back, please. Ms. Goldstein, you're going to take that question.
I think I got here late, so forgive me.
Yes, please.
But it's called an Expungement Forum. And I believe everybody here understands that New York State doesn't expunge any felonies.
Okay, sir.
Wait,
Sir.
I have a question.
Okay.
I have a question. When you was talking about the certificate of relief of disability, which is being underutilized by brothers with felonies and brothers and sisters with violent misdemeanors, they do issue your disability certificate. However, there's 3 block boxes on the certificate itself. And if they don't check the bottom box on the certificate of relief of disability, your civil rights or those rights have not been restored to you. I have a certificate of relief in my pocket right here, and I have it checked with an amendment. And if it's not checked, in the bottom box on your certificate of relief of disability, and I'm telling all of you who is trying to get one, if they do not check your bottom box, your rights have not been restored to you. You cannot get a gun permit, and you cannot get anything. I'm telling you now, I filed online with the DSJC or whatever, for a certificate of relief. It was denied because they said I didn't have 2 felonies. Listen, this is a joke. If you sit up here and you fall for this, you are insane. You're not gonna get nothing. Take my word for it. We're happy to meet you. We appreciate that.
Okay. I'm coming to you. I'm coming to you.
Let him answer the question for you.
Can I go next?
Okay.
Can I go next? Let me go next.
Okay.
Let me go next. Let me go next. Let me go next. Let me go next. You should not go first. You should, no, I know you do. That's why you shouldn't go first. That's why you shouldn't go. You don't say you from yourself. All right. So All right, so where'd he go?
We here, it's not only him, it's we.
I like we and us and all that.
There you go.
You know? Yes, I do. You don't know me like that,
You
brother.
already said you don't care.
You don't know me like that. So let's talk. Let's be serious. Let's talk.
Represent,
For real.
brother.
So that's probably an example of what can happen. That's true. So let me give you another example. So I've been doing this now for 24 years. 24 years now. So I have clients who have filed for their certificate of relief of disabilities. I have clients who actually committed crimes, filed major crimes, felonies, were working for the city while they did it, while they committed these crimes, got convicted, went to prison. We helped them file their certificates while they were in prison. When they got out of prison, they then got a job back working for the city. So in my opinion, my humble opinion, and in doing this for a long time, so I can say this, it does work and it does help. There are situations when it does not. There are situations when it will not. But that should not stop you all, or those persons, from trying to do it. Like Seth said, and like the brother pointed out, of course, 2 is not enough. That's not enough. No one's going to say that it is. But I'm telling you that I have been a part of this expungement sealing fight for a long time. And so we're trying to get this thing to a place where, yes, it helps more people out than it does right now. But however, right now, the sealing statute right now will, and we can argue about how many all day, but will help more people. Will it help enough people? No. Different question. Absolutely not. Anybody says that it will is crazy. Absolutely, positively, unequivocally will not help enough people. But will it help more than it's helping now? Absolutely. So the reason why these persons have taken time out their days to come in here and explain this to the community, which hasn't happened in any other community yet. Let's be clear on that. Hasn't happened in any other community anywhere in the state. Why do I know that? Because I just left Binghamton an hour ago to get down here. I'm in Albany often. I'm all over this doggone state. It hasn't happened yet. So the fact that these people are taking the time to try to get more people to apply so we can get more people than are being disenfranchised now to become more productive is a good thing. And the ones that it doesn't help, we're trying that too. So please, do it for me, like the commercial says, all the loved ones in your life. If someone is eligible, apply. If someone